SJC-11914, Commonwealth v. Adorito P. Amado.
Still phones to jocks. Good morning.
Good morning, Judge. Susan Taylor for Mr. Amado. May it please the court. This case arises from a motor vehicle stop that was effected by the Brockton police. A motion to suppress was denied by the motion judge. The motion judge really focused his decision on the latter part of that stop, which encompassed what we would urge the court to say was a strip search. But as a preliminary matter, it was clear that at the time that the car was stopped, the basis for the stop is that the tail light was, or the license plate light was not properly illuminated. So it was a civil motor vehicle infraction that precipitated the stop by the Brockton police. Now, when the police stopped the vehicle, and there were 4 police officers in the chase vehicle, and there were 3 men in Mr. Amado's vehicle. Mr. Amado was the passenger, was the front seat passenger. Now, the Brockton police were familiar with Mr. Amado because more than a month earlier, they had stopped a car in which Mr. Amado was a passenger, and there was a gun under the front passenger seat. So at the time that the police stopped this car, we don't dispute that it was a valid motor vehicle stop. So at that point, going to whether or not there was a valid exit order, under federal law, under the 4th Amendment, it's clear that the police could order Mr. Amado out of the car under Pennsylvania v. Mims, but at least under Massachusetts law, in Article 14, it's clear that they have to have something more in order to order the passenger out of the vehicle. So what is that something more? And in this case, it could be for officer safety, it could be probable cause that Mr. Amado was committing a crime, or it could be that there was some sort of independent reason to conduct the search of that car.
I mean, the only reason advanced was officer safety, right?
Yes.
And are you disputing that there was a valid basis given the arrest 2 weeks or a month before?
No, I think it's reasonable to concede that if they had arrested Mr. Amado previously, that could give rise to legitimate safety concerns. But then the question becomes, what is the scope of the search that they could then conduct on Mr. Amado?
Before we get there, if I can, you don't make the argument, well, you can't, I understand that, but am I right that there was evidence at the motion to suppress that the police saw that Amado was in the car and followed it because they wanted to see what he was up to and basically were looking for some reason to stop it, and they found the light on the license? That was in the evidence, right?
That was in the evidence. I would suggest that it was. I think that you could reasonably advance that this was a pretextual stop. The police say that in fact, the police officer admitted that we saw him, we decided to follow him, we saw the license plate wasn't properly illuminated, and that was good police work. That's what he termed it. It was good police work on our part to pull over this car. So at that point, when they asked Mr. Amado, they make certain observations about Mr. Amado. They say that he's nervous. They see some movement, and based on that, they conduct a pat frisk. And I would suggest to the court that the police officer's candor in the degree of that pat frisk is remarkable, because he says that he runs his hand up his inner thigh underneath his testicles. And I would suggest to the court that that's not a proper pat frisk. It's not within the scope
Seems like a little over the top for a weapons search.
Certainly if he's looking for a weapon. I would suggest to the court that the pat frisk has to be confined to the outer clothing and areas where someone would hide a knife or a gun or some other kind of weapon. So that, and when
But
Mr. Amado.
isn't there a problem? I mean, Ms. Lee gives a whole list of cases in which people have hidden things in or around their groin. If you basically, if the word gets out that you can hide things there and the frisk will not find it, would that not then become the place of choice to hide small weapons, small blades, small other things that may be potentially dangerous?
Well, Judge, with regard to my sister's brief, I don't stand before the court today urging you to make a per se exception and to say that there is this safety zone under the genitals in which no police officer in any circumstances can search. But that's not the case here. This is a case where a young black man is stopped in a vehicle and for a civil motor vehicle infraction, and he's the passenger. And instead of confining that search to his outer clothing and maybe even the immediate grab area under his seat, they conduct a search under his testicles. I would suggest.
And even if that is not enough, wasn't it clear at some point that that was not a weapon?
Didn't he say
The
that?
police officer said that when he detected the package, it was clear it was not a weapon.
Did he go, I couldn't open the transcript of the motion hearing, so I just saw Officer Donahue's testimony at trial when he talked about feeling this item and I think saying he knew it wasn't a weapon, but that based on his experience, people, and he said to his colleagues, he's jocking something because his experience was people hide drugs there, right?
Yes.
So do you think at that point, did he say that he had probable cause to search for, what did he say at the motion hearing on that point?
The location of the package, which he said was not a part of the male anatomy, was to him the probable cause that necessitated the subsequent pulling back of the waistband of the shorts.
And what's your answer to that?
Well, I would suggest that this case is just a little bit different from Commonwealth versus Morales, where the circumstances were, and Justice Gantz and Justice Cordy wrote concurring opinions where the court found that the strip search itself was unreasonable, but both those justices found that the pulling back of the waistband was reasonable. But I would suggest that we don't even get to whether or not the search was reasonable. I think we first have to determine whether there was even probable cause on finding this package.
That's what I'm asking you. So what's your, you say that Officer Donahue indicated that, I didn't see it in the trial transcript, but you say that he indicated at some point that he did have probable cause to search for drugs?
Well, that was the basis, that was the probable cause for the search, was the
Okay, and
detection.
what's wrong with that from your perspective?
Well, unlike in the Morales case, where there was a confidential informant, they had seen Mr. Morales engage in a number of different interactions with people which led them to believe that he was a drug dealer. In this case, other than the location of an item in Mr. Amado's underwear.
And his nervousness, the heaving chest and the rest of it?
Yes. Whether or not that gives rise to probable cause, I would suggest that it doesn't necessarily give rise to
So
probable
would you
cause.
say it's a reasonable suspicion, but it doesn't rise to the level of probable cause? Is that where you are?
I don't think that it does. Because probable cause what? I mean, what somebody would put under their testicles, I guess is anybody's guess.
Well,
And
when you say anybody's guess, but is a practical matter, didn't he testify that after he did the pat frisk and ran up his hands up the outer layer of clothing and felt a hard object, it didn't feel like a gun, it felt like some other kind of a container. And based on his experience, he said the only other possibility was drugs. Isn't that what he said?
Well, that's what he said, but I mean, is that?
Is that
with
is that
objective
so illogical?
reasonableness, I
He
mean,
didn't
is
say
it-
that, did he?
Is it reasonable that someone could have something other than drugs in their underwear? Because there's no other indicia that would give rise to probable cause. I mean, he wasn't under suspicion as a drug dealer. There's none of that evidence. The initiation of this stop is from purely a unilluminated license plate. And the officer's Donahue's testimony doesn't say that he knew Mr. Amado as a drug dealer. It said that they knew him from a prior stop in which a gun was retrieved. So even if you were to decide that the scope of this pat frisk was reasonable in these circumstances, I would suggest that they still did not establish probable cause that he was jocking drugs. And if the court were to find that even there was probable cause, the question then becomes whether or not a strip search was reasonable in this case, and that the manner of the strip search was reasonable. And what I would suggest is that the fact that two of them pull his underwear back, they shine a light in, and the government terms this whole process as minimally invasive. It seems to me that, forget about my house, the genital area is termed the last bastion of privacy for us. You have to have more than just you're a passenger in a car.
Incredibly humiliating.
Yes, and
Incredibly
I would say-
humiliating. Have
and
your
that if you-
shorts pulled back? Oh, I can't.
And that the strip search itself, strip searches, they're said that they're demeaning, dehumanizing, undignified, humiliating, terrifying, unpleasant, embarrassing, repulsive, signifying degradation and submission. And I would suggest to you that that's exactly what that is.
But let's imagine, put aside the issue of whether there was probable cause for a moment. Let's imagine a situation in which they received CI information that said, Mr. Amado is carrying drugs. His routine practice is to carry it in his jock. That's where, when he sold it to me, that's where he pulled it from. Same thing happens. Is it okay for them to do it under those circumstances? Is the issue really the probable cause to believe that those are drugs, or is there something beyond that would forbid them from doing what they did, even if they had reason to think that there were drugs there?
Well, assuming for a minute that there is probable cause to
Right,
believe.
that's why I say, put that aside. I'm not asking you to concede that point at all.
Okay, so assuming that, so I think that first of all, there was no policy from the Brockton Police as to what their policy is to conduct a strip search. And the question of whether the removal of the last layer of clothing is the strip search. There was no exigency in this case. They could have I think it's Perfette or Thomas, where they put him into a windowless, basically paddy wagon where they conducted the search.
So, and what would be the basis of that?
But
You
in this
mean if we
case-
assume probable cause? Is that what you're saying?
But I even think that at that point, they could have taken him to the station, to a private room. The testimony itself is that they look into his shorts at the roadside, and then when the supervisor arrives, they escort him to what they say is a more private area between buildings, but the testimony is that that was a residential type of neighborhood. And so the question becomes whether or not that's reasonable. And I would suggest to the court that at least in terms of the scope of the pat frisk and the search of Mr. Amado was unconstitutional. And I have exactly 54 seconds left, so I would only point out to the court as well that this is a case in which the specter of Annie Dukin also hangs over. She was the confirmatory analyst, although the drugs were subsequently retested. At the time of Mr. Amado's trial, this court had not yet rendered the Scott decision, and
Could I just ask you one question about that? The weight of because he was charged with trafficking, right?
yes, he was.
And the weight was 24.2? Is that?
Yes.
And what's the, I don't remember at the time, what's the,
It was trafficking more than 14.
more than
But,
14?
So,
Okay.
but in terms of, and I would point out that the drugs from his case were in the lab at the time of the so-called June breach. So the June breach occurred at the end of June. and
But they were retested by 2 different people.
They were retested. But
Wasn't there
I
a
would-
stipulation regarding the fact that I can't remember the scope of it, but something like she also had agreed that she sometimes added drugs to make it really drugs. So on retesting, you'd have cocaine because she would put it there, is the idea?
Yes. I would also point out that at least as far as that goes, there was a stipulation, but the stipulation itself was so tepid, and when there was a cross-examination of the remaining analyst, she basically said, I never saw Annie Dugan do any of those things. I don't know if she did those things. So it was the fact that the drugs were retested and that there was misconduct. The stipulation in this case, I would suggest, was of no assistance to Mr. Amado. I realize it was done because at that point, the court system had not quite caught up to this new problem. And unless the court has any other questions.
Thank you.
Thank you.
Good morning. May it please the court. Mary Lee, Assistant District Attorney from the Plymouth District for the Commonwealth.
So isn't the first issue really how far can a pat frisk go in these circumstances?
Actually, Your Honor, I would disagree. As I noted in my brief, that was not the issue that was raised at the appeals court and under Lombard. That's not the issue that's addressed here. You'll see in the motion transcript, if you haven't already, that the defendant's claim was really going to the Morales issue on the strip search claim.
Had Morales been decided by the time Judge Gaziano decided this motion? I mean, it was the same month,
The
so I
answer is
couldn't
no,
tell.
no, it was actually, it was.
Some days later?
The judge found it on March 12th, and Morales was, I think, in May. So Morales had not come down yet, I checked that.
Thank you. Thank you. I didn't know the answer to that, so I
Well, Judge
appreciate
Gaziano usually knows our laws,
Well,
so
that's why
the absence of Morales
I was
caught my
assuming that it
attention
hadn't come
and-
down yet, because you
Right,
didn't
and
mention
it had not.
Right.
It was 2 months away.
Right, and when you look at the defendant's affidavit in support of his pretrial motion and his pretrial motion, the pretrial motion is not talking specifically about the pat frisk, and his affidavit only talks about the search. The focus of the hearing was the strip search itself, the claim of a strip search, and whether this constituted a strip search, and if so, was it reasonably done and based on probable cause. And so I would suggest that under Lombard, this court shouldn't hear it on further appellate review because it hasn't been properly preserved. And had it been properly preserved at the pretrial stage, under MUBD and Rule 13, the Commonwealth could have presented evidence like you see in Commonwealth versus Cruz-Rivera, cited in the Commonwealth's brief, where the officer talked about weapons that had been found in the crotch of people's pants, and that would have been further helpful to the court, both in the motion hearing on making its findings about
But he said
that.
he knew it wasn't a weapon, so how is that going to help the
Because that's,
Commonwealth?
I'm sorry to interrupt you. That's after the pat frisk that he knows that it's not a weapon, not before. So if you're talking about the scope of the pat frisk itself, then you would need the officer's testimony about whether weapons are kept in the crotch of the pants, as you have in Cruz-Rivera. And we know weapons are kept in the crotch of their pants as well from the case law that I've tried to present to the court. So I would ask first that this court not address the question that this court has asked, has solicited amicus briefs on, although none were provided, whether a police officer can search behind the testicles of a male suspect, because that was not properly preserved, that was not the focus of the hearing, that was not the subject of the motion judge's rulings, and it was never presented to the appeals court. So under Commonwealth versus Lombard, I would suggest it would not be appropriate to address that question this court has asked. And further, I would object under MUBD. This is my first opportunity to object under MUBD to hear it without us being able to present that kind of evidence. On the merits, the Commonwealth would suggest we had reasonable suspicion for the exit order that justified the exit order under state law. It's obviously appropriate to remove the passenger under federal law. And what you have, so let me start with this. I hear your concerns. The first time I heard, the snapshot of this case is like, whoa, you're a passenger in a car with an unlit license plate, and now the police are looking down your pants? What? I hear you. That sounds horrible, but that's not this case. What this case is that Adalberto Amado is known to the police officers. They were following the car, they see the tag light, and that is under Commonwealth versus Santiago.
Saying it's not legal, but it's
I hear you.
offensive.
I don't think it's offensive, Your Honor. I disagree with that. But I hear your concerns, and I want to alleviate your concerns with the facts of this case. Because what happened here is the police stopped the car. It's proper to stop the car under Commonwealth versus Santiago and the CMR that the judge considered, and Commonwealth versus Garcia. And what they see of Adalberto Amado, who they know has 37 days before had unlawful possession of a firearm, as he's a passenger in a vehicle, they see the reach. It is the left hand going back to the pants. Now, in Commonwealth versus Morales, which was the Commonwealth's appeal, the Commonwealth was obviously married to the findings of the motion judge. That's what we have here, the findings of the motion judge. That reach occurred, reaching back with the left hand to his pants, to his back, I'm sorry. So then they go up to him, and they don't just know him from that 37 days before. They know him because of numerous occasions, which the judge found, and he didn't detail them, but you'll see them in the motion hearing. This person was a witness at a recent homicide, and the defense at the motion hearing was trying to suggest that because he didn't cooperate as a witness, that's why the police were following him. This person had a trespass, a larceny of motor vehicle, and numerous other interactions with the police. Why is that important? They know him. They know how he normally acts. And today, at this stop, he's not acting like his regular self. He's usually engaging, he's usually communicative, and he is different today. And it's making the police worried.
That's not what I was saying offensive. It was, I'm back at the stop. I just think they're looking for a reason to stop. You don't disagree with that?
That was the I agree they were following him. I agree that the police officers saw the tag light. I agree that they said this was good police work to notice the tag light. And when you can, I'm calling it a tag light, it's the license light. You all know what I'm talking about. The wire is hanging down, and they can't see. They're trying to get the license plate on, as they're following, and they can't because of the motor vehicle violation, which the defense witness actually agreed there was something wrong with the light, and he had tried to fix it while they were at the Hess gas station where they were first spotted by the police. So there is something wrong with the license plate. Even the defense witness said so. So although he said he tried to fix it as they were leaving. At any rate, so the police couldn't read the license plate, and one of the officers was aware that this is a violation, and that's why they stopped them. And so under Santiago, I would, the Commonwealth's position is that it is not offensive. It is proper stop, which the defendant concedes in their brief. So then they have all this information to get him out of the car. I would also note that the driver was taking evasive movements, et cetera, and they get him out of the car, and they want to make sure there's not a gun there, and that's why they do the pat frisk. And I am very firm in my belief that if this court changes Terry law to say in Massachusetts you cannot do this type of pat frisk, you're going to endanger lives, not only of the police, but of the public. Okay. Because the pat frisk is to ensure that there's no weapon. And one, we were never able to present evidence that they could put a weapon there. Okay. And two, people can put weapons there, as I've noted in my brief.
But the pat frisk is done, and he finds something that is not generally in the crotch area, and he says, "What is it?" And Mr. Amado says nothing.
But he does say it's not, he knew it wasn't a weapon.
Yes, he does say that.
So it's plainly something that he is denying, but what's the probable cause to believe it's something that would allow, I mean, you're essentially claiming that at that point in time, he had probable cause to arrest him.
Once he feels the item in the crotch of the pants,
or at least after he says, "What is it?" and he says nothing, you would say he could have at that point arrested him.
That's probable cause. Yes, he could have arrested him under Commonwealth versus Clearme.
But Clearme, it was a search incident to an arrest. He'd already been arrested on a warrant.
He was arrested on a warrant, but under the search incident to arrest, you have to arrest for something relevant to the crime. And if you, I actually presented Clearme to this court back in 1995, so I have some familiarity with it from memory, as well as reading in my brief. But in Clearme, he was arrested on a warrant. The warrant was for, I believe, a trespass or something that you would not expect to find fruits of the crime on his person. So the search incident to arrest for the warrant would not have gotten us into the pill bottle inside his
Did
pants.
he know, though, that it was contraband, or did he had merely a suspicion that that's what it was?
Thank you. I was just about to answer that question, which Justice Botsford also asked. It's the motion hearing, the third day, and it's Detective, I think it's the third day, and it's transcript page 23 and 57. So at 23, he is saying, based on his training and experience, he knows that's a common area, the crotch, or secreting it along the buttocks. Basically, narcotics are usually bagged, and it's basically to prevent detection by law enforcement officials. And then he goes on to describe a particular instance where he saw that had happened. And then on, I believe this is cross-examination, I could be incorrect, but at page 57, he's being asked, so from the feel of it, so they said touching it alone was not enough to tell you. He says the feel of it, the area of it, my knowledge of them, people crotching things in that area, past occasions, experienced people, watching people crotch narcotics. From my training and experience, I had a very strong suspicion it was narcotics. He didn't know what type of narcotics was, but then going down lower, I believed it was crack cocaine.
Well, I guess, I mean, but your sister points out, and I guess it's true, no evidence here that he had ever been arrested for drugs, ever been involved in drug dealing.
That's true. The prior...
You got no reason to believe that he is in any way involved in drugs.
Right, the prior incidents were the firearm, a trespass, larceny, motor vehicle, and a witness at a homicide who was not cooperating with police, and then the officer said, and numerous other events, none of which, he didn't describe them, but drugs were not mentioned as his prior history. But I would suggest...
Don't you need that to move from a suspicion that it might be drugs to probable cause that it is?
Well, here's the information that the police officer had after the pat frisk that I say supports probable cause to look inside the pants. That a foreign object is secreted in an area behind the testicles in the buttocks area. They know it's not a weapon. The defendant was asked about it, and he said there was no object there, which the judge found to be patently false or obviously false. The crotch and buttocks are common hiding places for drugs to avoid detection by police, which I've just read a portion of the officer's testimony on that. During the pat frisk, they felt money in the pocket. The defendant said it was $500 in cash. The defendant was unusually nervous given the police knowledge of him and their numerous encounters, and he's acting all different today. The driver used evasive techniques when the police were following, and the defendant had reached into this area. Now, the reach does two things. He reached into this area, and that causes the police, like, the movement up front, you know, and now they're worried, and that's why they take him out to search him. But also, when he's reaching into this area behind him as the police approach, I would suggest that supports the inference that the officer drew, that he's jocking something, and that this jocking something was drugs, which he believed was crack cocaine based on his experience and having touched it. So I would suggest in those circumstances...
Based on his, he could feel that it was, he didn't say that he could feel
He didn't know.
what it was.
He didn't. He said I had a very strong suspicion it was crack cocaine.
But he knew it was not a weapon. Did he say why he knew it was not a weapon? Because it was soft? What made him sure of that?
His description of what it felt like was that he knew it wasn't a body part, it was not part of the male anatomy, but that it was not a weapon. So I would suggest the reasonable inference that is the weight and texture of the material that he's feeling as he's blading the
But he
hand.
didn't describe its texture or anything else that
He
would...
did not.
He said it was
But
a
I-
hard object, right? Or did he not?
He said it was an object that was obviously not part of the male anatomy.
He didn't use the adjective
I
hard.
don't think he used the word
Okay.
hard, but
No, I'm not trying to put words in your mouth.
No,
I thought he had.
I don't think that he used the word hard because he was specifically trying to describe that he didn't think it was part of the male anatomy.
But you agree that at that point, there had to be probable cause to arrest for the further search?
Yes, and that justifies, because under Clear Me and Chiamataro, it doesn't matter whether the search occurs before the formal arrest or after the formal arrest. And so that's the evidence that we have. I suggest to you that is probable cause based on the officer's experience and knowledge. And this telltale area is very much like Clear Me. It's this telltale area where you carry things. There are numerous cases of weapons being carried in pants, as I've said, but there's also numerous cases of drugs being carried in the crotch of the pants, which I tried to lay out as well, and the officer testified.
Could I ask you this? Judge Gaziano, because Morales hadn't been decided, he didn't treat, I mean, he specifically said this was not a strip search. So he didn't, if I'm recalling, he did not really address the probable cause issue. Is that,
No, I think he found probable cause.
did he, for the
He
search?
did. He said it wasn't a strip search, but that was probable cause, and this was to search in the pants,
Okay.
and that this was reasonably done, and that was what the appeals court found as well. And
I didn't really
rely
think the
on
appeals court-
Judge Gaziano's decision is at Defendant's Record Appendix 21, in this, and it says non-invasive and reasonable search, and the appeals court is Defendant's Record Appendix of 41, which found, it's found that it was a strip search and that it was reasonably conducted and constitutional. Now, whether it is in fact a strip search or not is the question that this court left open in Morales, and I would ask this court to find that even if it was a strip search, it did have probable cause and that it was reasonably conducted. I would note to the court, as found by Judge Gaziano, that the defendant was given the opportunity to avoid it by removing the object from his, First, they did the pullback on the pants and saw the plastic in there. There was nobody in the area, it was dark, only one of the two officers pulling the pants back saw inside. At that point, they offered to let the defendant retrieve the item, and he declined. And that, I would suggest, goes to reasonableness. This could all have been avoided, this alleyway. The other officer came...
Second time. it could've
Second
been.
time.
The first time, you're not saying that could have been avoided.
No, but he was asked, what's in your pants? And he said nothing. So he could have avoided the first time as well if he said there were drugs in his pants. So I would suggest this was reasonably conducted under profit. It was a proper search, even though the defendant was removed his clothes down to his underwear. Thomas, the person was entirely naked, and they viewed inside his body cavity, and that's less than
This
that.
is not Massachusetts.
No, Thomas is Massachusetts,
Thomas?
yes. That, he's taken back to the station.
Ah, okay.
He's stripped
Just not on the
entirely, he's
street.
completely naked. He takes out one bag, the police take out another bag, and then they look inside his body cavity and see a third bag. And those were both proper. And this is far less than that, even though it's outside. Even if he had been taken to a police station, the only people who saw his buttocks area are the people who would have seen his buttocks area at the station had they conducted it at the station. And the defendant here was given the opportunity to avoid that search.
Well, you can't pick this search up and put it in the police station. It happened outside.
No, I understand, but this isn't as far as Morales, which, where the buttocks were exposed to the public. And Profit was actually, it was at the scene, but inside a van. And the police took steps. They moved to an alley. They made sure nobody could see out. They made sure there were no onlookers, so that the only people who saw the buttocks area were the police themselves, who would have been the people who saw this search, who saw inside the pants at the police station if it had gone there. And so I would suggest the findings of the appeals court and the rulings of the appeals court and the motion judge that this was conducted reasonably are correct, and I would ask this court to affirm the convictions.
So before you sit down, Justice Botsford's question about Judge Gaziano's findings, I thought you were right, but I'm looking at it again, and I don't know that you are.
I don't see it, no.
He says, having lawfully discovered the highly incriminating plastic baggies, the police officers possessed probable cause to believe that it contained narcotics. But that was after they had retrieved the baggies. I don't see anything that he says that there was probable cause at the time of the pulling of the clothes. He doesn't say there wasn't, I don't find him saying that there was or was not.
And the same for the appeals court.
The appeals court assumed that this was...
It doesn't talk about it, though.
Without deciding that it was a strip search, and I specifically remember that. And this says, in the present case, the totality of circumstances gives rise to a legitimate and reasonable basis for,
Page 7 of his opinion, page R20 and 21.
I think because I was saying that he's talking about whether a strip search is decided. Yeah, he says pulling the waistband was not a strip search. He describes how it's defined as a strip search.
Right, so from his perspective, it seems to me reasonable suspicion might well have been enough.
You know, I think I'm reading the last line differently than you, so I apologize if I've drawn the wrong inference. He says, having lawfully discovered the highly incriminating plastic bag, as the police officers possessed probable cause to believe that it contained narcotics and to seize the narcotics in a non-invasive manner. And I think I read that as they when they were blading, they found the object, and so I apologize if I've misled the court on that. I was reading that as him finding probable cause from the.
Right, well, that's what I thought when I first read it, but I
Yeah,
think
so
all he's, I mean, I guess once they saw the baggies, they saw that it contained something that certainly appeared to be drugs.
Oh, sure.
So that was a different, that was more information than they had before they
Right, at the
pulled
blading, and so
pants.
I did, however, correctly describe the factors that I say support probable cause once the blading's done and they feel the object there. And,
Say that it was a hard object, I don't know which way that cuts, just to
right,
clarify.
well, regardless of whether it's a hard object or not, he knows that it's not a weapon, and so,
Right.
from the feel of it. I would only point out on the Annie Dukin issue that Daniela Frasca and Nicole Medina both testified, and Daniela Frasca testified that she checked the bags when she went back to do the second test after Annie Dukin's no longer at the lab. She checked the bags that she had previously heat sealed and checked them for punctures and tampering and found none and continued on with the test. So I would suggest that that would negate any presumption or otherwise that this court would suggest came out of Scott, which postdated the trial in this case.
Okay, thank you.
Thank you.
I think we'll take our morning break.